Welcome back, viewers. You're watching the Savera. I'm Shefali. The Supreme Court on Wednesday declined to give an out-of-turn hearing on a plea seeking direction to the Delhi police to register an FIR and cause an effective and meaningful investigation into the allegations that a huge pile of burnt cash was discovered at the bungalow of Justice Yashwant Verma on the Delhi High Court. When the matter was mentioned for an urgent listening, a bench headed by CJI Sanjeev Khanna told Advocate Matthew Nedumpara, the party in person, to not make public statements. "Sorry, Mr. Nedumpara," said CJI Khanna, adding that the registry will list the petition in due course. Questioning the non-registration of FIR on March 14 itself, the day this unaccounted cash was reportedly found after a fire brigade has gone to Delhi HC Judge Justice Verma's residence to douse a fire. The petition said that the delay on the part of the authorities concerned to make available to the public the electronic records lead to the irresistible inference that what was going on was an attempt at a cover-up. Why no arrests were made? Why the money was not seized? Why no mahazar prepared? Why the criminal law was not put into motion? Why did it take almost a week for public to know about the scandal? Justice Verma, in his explanation, has stated that it is not his money, that he had never kept any money. He is fully taken aback by it. Then why did he not report to the police and seek the registration of an FIR of an attempt to falsely implicate him? The petition further said. The case at hand is an open and shut case. It is a case of holding black money accumulated by selling justice. Even attempting to believe Justice Verma's own version, the question still remains as to why he did not file an FIR. Filing an FIR, even belatedly, is absolutely necessary to engage the police to investigate the conspiracy aspect, contented the plea. It said, in Justice Yashwant Verma's case, no FIR has been filed to knowledge of the petitioners. The public perception is that every effort will be made to cover up the issue. To extent, even the initial statements regarding recovery of money are being reputed. Further, it sought the declaration that the three-panel member constituted by the SC Collegium has no jurisdiction to conduct an investigation into the incident and is void ab initio since it constitutes various cognizable offences under the BNS, saying that the corruption is the judiciary substantial and directly infringes the fundamental rights enshrined in Part 3 of the Constitution. The petitioners said that they, as a citizen of country, have every right, unquestionably locus standi, to directly petition the Supreme Court. The plea questioned the judge of a 5-judge constitution bench in K. Veeraswamy versus Union of India case, where it was held that no criminal case should be registered against a judge of the High Court, Chief Justice of a High Court, or Judge of the Supreme Court unless the CJI is consulted in the matter. The said observation of the court is one rendered per incurrum, in ignorance of law, sub silento, without noting the police are under a statutory duty to register an FIR when it receives information of a cognizable offence, and its said direction of the court is nothing short of restraining the police from discharging their statutory duty. The plea said that such a direction creates a special class of judges, immune from the penal laws of the land, and had stood in the way of an FIR being registered even in an offence involving POSCO. The Supreme Court appointed 3-member committee commenced its probe on Tuesday against Justice Yashwant Verma of the Delhi HC. The inquiry panel visited Justice Verma's official residence and reportedly spent over an hour inside the bungalow, where allegedly a huge pile of burnt cash was discovered in the storeroom after the fire brigade has gone there to douse a blaze of March 14. That was all for now. For more updates, download the Savera app, follow us on Facebook, Instagram, Twitter and YouTube.